SJC-11498, Commonwealth v. Carmelo Torres.
Yes, Counsel. Good morning.
Good morning, Chief Justice. May it please the Court, I am Stephen Kelly. I represent the appellant defendant in this matter, Mr. Carmelo Torres. Mr. Torres was convicted back on December 12th of 2011 of intentional assault and battery on a person with a use prevention order under Chapter 209A, and also of violating that same 209A order. There are two issues before you today, Your Honors. The first issue deals with the sufficiency of the evidence matter. The second issue, which I would like to handle first, deals with whether or not my client can be convicted of both intentional assault and battery on a person with a 209A order.
You say that it would be duplicative to do so.
Yes, Your Honor.
But aren't the offenses different? Don't they have different elements?
I don't believe so, Your Honor. In analyzing both of the statutes, in order to prove intentional assault and battery of a person with a 209A order, you must prove first that there was an assault and battery. So the elements of assault and battery would be in play. And then you have to prove both the existence of the 209A order, and you have to prove that the defendant knew about the 209A order.
But not that the 209A order was violated.
Right.
However, Your Honor, I would argue that it would be virtually impossible not to violate a 209A order by assault and battery on the alleged victim.
But that's not what the statute requires. It only requires that the person be protected by, that there be one in place, and that the defendant know about it. It doesn't require that it be violated. So the fact that it has been violated doesn't seem to me necessarily to go to a statutory element.
Well, I respectfully would disagree with that, Your Honor. I do believe it does appear to me when in evaluating the elements here, assault and battery I refer to Commonwealth or Edge versus Commonwealth in my
That's
brief.
a different statute. That is a different statute.
It is a different statute, but the stalking statute is a statute in which it is possible to not violate a 209A order, even though somebody may be stalking, because stalking focuses on the conduct of the individual who is alleged to be the stalker. Whereas in a 209A order situation, we're looking at a 209A order is issued where is based both on the conduct of the alleged perpetrator, if you will, and the perception of the person who was asked for the order.
But you don't think it makes a difference, though, in the stalking case, the enhancement statute, the one that mentions 209A, or says stalking in violation of that order, whereas this one is assault and battery of somebody protected by, so that the
Right. I think in this particular in the assault and battery case, it's not necessary to mention that as in violation of, because an assault and battery, by definition, is going to violate the 209A order.
Counsel, apart from focusing on elements to determine what the legislative intent was, whether to punish for both, is there any value in looking at Section 7, this language that the criminal remedies herein are not exclusive and don't preclude any other criminal remedy?
Well, that may
indicative of any intent, or
that may
not?
be, but the idea a duplicative conviction and double jeopardy is that person is being punished for the same conduct, for the same act. And in this case, Your Honors, I would say that the assault and battery on a person with a 209A order and being convicted of the violation of the 209A order are one and the same.
Now, if you're convicted of a 209A violation, you're required to complete a certified batterer's intervention program unless the judge otherwise orders.
Yes.
If you were right, would there be no such requirement?
Not necessarily, Your Honor. The judge could, in assault and battery case, order such a condition of probation or as part of the sentence. So certainly that would be within the discretion of the trial judge.
But the statute makes it presumptive.
Yes, it does.
And you're saying that you'd have this somewhat strange situation that if you're convicted of the more serious offense, you would lose the presumptive batterer's program. You would have to then rely upon the judge imposing a period of probation and making that a condition of probation. Does that make sense, especially in light of Justice Duffy's question about the provision of the statute which speaks about 298 not being the exclusive remedy?
Well, again, Your Honor, focusing on the conduct and whether or not we're punishing for the same conduct. One of the things that, by charging an offense as assault and battery on a person with a 209A order versus simply an assault and battery and a violation of the 209A order, it steps it up to a felony type of offense as opposed to misdemeanors. And so the enhanced punishment, Your Honor, certainly could weigh in that. And it's, again, within the discretion of the judge to order the batterer's program. And I think in most cases today in the Commonwealth, that is, from a practical standpoint, being done. In addition, there's nothing to say that the legislature could not change the current statute to say that if someone were convicted for assault and battery on a person with a 209A order, that would not also could not also trigger a mandatory batterer's program.
If you could turn to your sufficiency issue as to self-defense, I gather that there was some evidence that she was half the size of the defendant, that there was some mention of that during the course of the trial. Why would it not be sufficient, at least as to the element of self-defense that requires that the use of force be proportional under the circumstances?
Well, Your Honor, my argument isn't that certainly the use of force would have to be proportional. The question here is, was there sufficient evidence to show that the use of force wasn't proportional, assuming that the self-defense argument. Now,
right,
the only evidence.
But I guess, my question to you is, if the jury understands that he is much bigger and much stronger
Yes.
than she is, and if there is evidence that he threw her against the CD case, would that not permit a jury to infer that his use of force, especially in light of the injury she suffered, was not proportionate to whatever aggressive action she took?
The evidence really, I think, on that comes from the alleged injuries, and that my client, I believe, in testimony stated that he pushed the alleged victim away from him after she had bit him on the arm. She then fell into the DVD rack. Now, how those injuries occurred is in question. Was it because of the defendant's actions, or was it because of her falling into the DVD rack? So I don't think we can infer just from the fact that she landed in the DVD rack, that was a disproportional use of force. Your Honors, on those issues, if you don't mind, I'll continue on. My argument on that is that there is not sufficient evidence. In this particular case, the alleged victim did not testify. She asserted her Fifth Amendment rights. And the only real evidence that you have is the neighbor who states that she heard an argument. And she heard that things being thrown around, but she wasn't in the room. And the only thing she did see was from the ground level, third floor, looking up at the third floor, that the alleged victim fell into the DVD rack. That's the only thing she saw, and then she saw the alleged victim afterwards. So while certainly a jury can make inferences based on the evidence presented here, there's just so many inferences that would have to be made in this particular case to say that would, and in my view, it seems to be conjecture that there was actually an assault and battery, especially in light of the defendant's testimony with regard to his actions, in which case he says that it was the victim, the alleged victim, who assaulted him, and he tried to defend himself and eventually wound up leaving the premises, his home, after several minutes.
Yeah, if I could clarify, it's not your position, I gather, that the evidence was insufficient at the time the prosecution rested before the defense case, is it?
Well, Your Honor, that motion was denied, but that would be part of my argument.
But at that point, there was no evidence of self-defense.
No, Your Honor.
So it was only, I understand your argument to be when your client testified
Right.
in his defense, then that raised the issue of self-defense and imposed upon the Commonwealth the burden
That's correct, yes.
to prove its absence beyond a reasonable doubt. So
Yes, Your
it's
Honor.
at the close of the case that you're focusing on the sufficiency of the evidence, not when the prosecution rested.
Well, I think both parts of that of the argument I think once there was evidence of self-defense, that certainly created more of an issue of sufficiency of evidence. But there is an issue of sufficiency of evidence beginning with the prosecution's case as well.
Because is it your argument on that score that when the neighbor testified, she saw if I have this correctly, when the neighbor testified, she saw the victim fall into the CD
Yes.
rack, you would say there's no evidence that he pushed her? Is that?
Yes, Your Honor.
So it's just, we don't know why she fell?
Don't
That
know
would
why
be
she
your
fell,
point?
Your Honor. We know we know the neighbor heard an argument, but and then saw her fall into a DVD rack. But so she's making inferences, as well as a jury would have to make inferences, which really seem to be more of a conjecture in order to get to a guilty.
But are you arguing, or did you argue in your brief, that the motion for required finding of not guilty at the close of the Commonwealth's case should have been allowed?
Your Honor, I believe I incorporated it was one sufficiency argument that incorporated both the state of the evidence and the self-defense issue. That was my intent anyway. And that seems to be what I thought that's what I argued, Your Honor. Now, with regard to the self-defense issue, the prosecution was then, once that issue was raised fairly, which we believe it was raised fairly, then the prosecution had the burden of proving that there was no justification. And my argument is that that in itself was insufficient. If there, I believe I'm starting to run out of time, so if there, are there any other questions?
Thank you, counsel.
All right, thank you very much.
Thank you, Your Honor.
Good morning, Your Honor. Stephen Greenbaum for the Commonwealth. On the second issue, and the statutory issue, I think this case perhaps clouds the issue somewhat because it involved a 209A order, the only term of which existed was refrain from abuse, and because the offense here was assault and battery. On those particular facts, you have this situation where the assault and battery necessarily is a violation of the order. But if you look at the A and B statute, the 2613A, it isn't limited to abuse prevention orders under 209A, so it includes orders including just simple domestic relations order to vacate the marital home, so that an assault and battery by itself would not automatically, even if a violation were required, wouldn't automatically be a violation of many of the other orders, and we're looking at elements, not facts. I'm sorry.
Well, I guess, and maybe it doesn't make a difference, but to me, if the only piece of if the statute were like the Edge statute and said you had to have violated it, in other words, that it was assault and battery in violation
Yes.
of and the only stricture of the 209A order was refrain from abuse, it arguably could fall into a situation, I understand about the elements, but it could fall into a situation where the facts. But I thought your point is we don't even need to go there because, in fact, the statute doesn't require a violation. It just requires that there be one in place and that the
All right,
defendant know
yes,
that.
the Commonwealth's position here is the plain language of the statute is pretty clear, that I believe, and if you look at the context of some of the provision about the enhanced punishment for an assault and battery on a pregnant woman, they're establishing a status of people for whom there's a special relationship and perhaps greater protection and a more severe punishment if someone's in that status, and the Commonwealth's interpretation is a recognition that in domestic relations situations where an order has been issued between the parties, there are heightened tensions, and both parties are on notice there should be refraining from violence. Yes. Of interest, just the Commonwealth would add we sent a 16L letter regarding Commonwealth v. Housen, I believe. It's an 83 Mass Ave court, and the court didn't grant review on that. That court cites the Commonwealth's position that the statute does not require proof of a violation, but then in deciding that it wasn't a lesser included, it seems to enter this analysis of the fact that there are other ways of violating 209A. And certainly the Commonwealth would suggest that that creates some confusion, that the better explanation is that there's no proof required of that.
No proof of any violation.
Of any violation at all, rather than that there are other ways of violating 209A, that's the more clear rationale. As for the sufficiency of evidence, I don't think the Commonwealth needs to go at length, although I will say Commonwealth's recollection of the recipient witness's testimony is not that she fell down, but that she watched the defendant push her into the DVD case. I think that's at page 33 of the transcript. But there's other parts of her testimony in addition, go beyond that, but that alone, that she watched him push her into the DVD case would be sufficient.
So in your view, I know your view is that there is sufficient evidence, but it would be, at the very best, the argument would be limited, as Justice Gant said, to the evidence at the close of the Commonwealth's case. At the close of the evidence, not at the close of the Commonwealth's case.
That's my understanding of the defendant's argument. I have not read, it's almost virtually impossible for that to succeed since the defendant is not required to credit any of the defendant's case, and we're not talking deterioration here.
Well, with regard to, certainly the case changes when he testifies, and that it brings into the case the matter of self-defense, correct?
Yes.
And once that's in the case, then the burden in the Commonwealth is to disprove beyond a reasonable doubt at least one of the three elements.
Yeah.
Did you disprove that the defendant had reasonable concern for his safety?
Eliminating the defendant's testimony, which the jury does not have to credit, looking at the light most favorable to the Commonwealth, well, perhaps not. Although in our case, there's no evidence they had a concern for his safety. We have the witness, the recipient witness heard him screaming and yelling at her for 45 minutes, telling her to shut up and go to bed, heard what she described as a fist to skin over and over again with him yelling at her. And I know the defendant focuses on his testimony. You hit me, you hit me. The defendant saying that. Perhaps what he's talking about, perhaps he's lying back and she's wailing away on him. But I think the more reasonable understanding of what the eyewitness's testimony in the Commonwealth's case is that there was an argument, both people were intoxicated, perhaps the victim struck a blow at one time which enraged the defendant, and he proceeded to pound on her for 45 minutes, which is why she came out looking the way she did, in addition to throwing her into the bookcase. And then he said, well, I won't go into what he said, but on that evidence alone, I think a reasonable juror could conclude he had no concerns for his safety.
Was there any discussion at trial as to whether or not self-defense should even be available in a case like this?
The prosecutor, at one point, I think at some point in the case when they're discussing the cards, the prosecutor initially argued against it, but then changed her mind and agreed that it should be there. But I'm not sure what her reasons were. I don't recall what the reasons were. There was a brief discussion, but...
You mean the prosecutor agreed that there should be an
Yes.
instruction?
Yes, there was an instruction.
Self-defense.
I mean, I guess my concern is how much of what you're arguing is an inference based on a gender stereotype, that it's the guy punching the woman. I mean, clearly there's evidence that he threw her against the CD. I understand that. But the fact that there was the sound of punches being made doesn't necessarily infer who was doing it, unless you say the larger guy is probably the one who's going to be doing the pummeling, which I understand is more likely the case, but I worry a little bit about gender stereotypes being the source of evidence.
Was there evidence, on that point, was there, I know there was physical evidence as to the victim
Yes,
and how badly she looked.
apparently, yes.
Was there any evidence as to physical injury he sustained?
Well, that was interesting. In his testimony, he claimed everything was due to her assaults on him, that her injured eye was a reflex action when she bit him in the elbow, and he did this, that he bit her, and he showed bite marks, whatever. And he introduced a number of photographs, which he said were of him the day after with these injuries. The Commonwealth, on cross-examination, introduced his booking photo and argued to the jury, well, look at that. I don't have the photos. I didn't look at that. But apparently there was a discrepancy between how he looked in his booking photo and how he looked in these photographs that he presented to the jury, claiming these were injuries inflicted by the victim. But there were photographs on both sides. If there are no further questions?
All right, thank you very much, counsel.
You're welcome.